Hello everyone, and welcome to Uncivil Law. To help increase your legal knowledge, please hit the subscribe button. It really helps our channel grow. For today's case, we are dealing with the border and immigration and an order issued by President Trump relating to the border. President Trump issued an order that denied people the right to immigrate if they couldn't prove they had health care insurance or other means to pay for their health care needs. This, of course, was extremely controversial. A whole bunch of people sued. The district court said that the people were likely to win and issued an injunction preventing the order from going into effect. In today's case, the Ninth Circuit Court of Appeals reviews the district court's grant of the injunction preventing the law from going into place and decides whether or not the district court was correct and whether or not President Trump's order relating to preventing people from immigrating into the United States is lawful as constructed. Let's get started with this. On October the 4th of 2019, the President of the United States issued Proclamation No. 9945, entitled Suspension of Entry of Immigrants Who Will Financially Burden the United States Healthcare System in order to protect the availability of healthcare benefits for Americans. The proclamation restricts entry of immigrant visa applications who cannot demonstrate that they have either the ability that they will acquire qualifying healthcare coverage within 30 days of entry or have the ability to pay for reasonably foreseeable healthcare expenses. So, people who don't have health insurance can't get health insurance and don't have the means to pay for themselves. In November of 2019, so one will take note that this is 1 month later, so the district court had no problem acting very quickly, the district court granted a universal preliminary injunction blocking the implementation of the proclamation and denied the request for the ability to stay appeal. So in late 2019, the Trump administration issued an order that prevented anyone who didn't have health care, couldn't get health care, didn't have the means of paying for their own health care from immigrating to the United States. And then 1 month later, the court said, let's just issue an injunction. We think that the people who are suing are likely to win. We think that what the Trump administration did is bad. And now, almost a year later, the Court of Appeals is going to review the district court and try to figure out whether or not they screwed it up. So let's figure out whether or not the district court screwed it up. Under the Immigration and Nationality Act, an alien seeking lawful permanent residence in the United States generally must apply for and be issued an immigrant visa. Before the consular officer may issue a visa, he or she must first ensure the alien is not inadmissible under any provision of the relevant immigration law. There are a number of reasons why an alien might be inadmissible under immigration law. An alien might be deemed inadmissible, for example, based on health-related grounds, the alien's prior criminal convictions, security-related grounds, or the likelihood will become a public charge. And that last quote is the one that's going to trigger today's thing. So the president made a proclamation, essentially, that people who could not obtain health insurance or otherwise pay for their own health needs would qualify as a public charge. And therefore, it's essentially like being on welfare is public charge. They're getting benefits from the government. So if you're going to immigrate and take benefits from the government, it's like, no, that doesn't work. Why are we admitting you? You're only a net drain. That's U.S. law. So it's like the president made a proclamation that people who couldn't pay for their health care would be a net drain on the United States. All right. Invoking his authority under the Constitution and the relevant law of the Immigration Act, the president issued the proclamation on October the 4th of 2019. In the proclamation, the president finds that unrestricted immigrant entry of a defined class of aliens, generally consisting of those who lack approved health insurance or the financial resources to pay for reasonably foreseeable medical costs, would, with certain exceptions, be detrimental to the interests of the United States. The proclamation further finds that U.S. government is making these problems worse by admitting thousands of aliens who have not demonstrated any ability to pay for their health care costs. In reaching this conclusion, the proclamation references data showing that lawful immigrants are about 3 times more likely than United States citizens to lack health insurance. Accordingly, the president determined in the proclamation that continuing to allow the entry into the United States of certain immigrants who lacked health care insurance or who demonstrated the ability to pay for their health care would be detrimental to the national interest. Based on this finding, The proclamation generally restricts the entry of immigrant visa applicants who cannot demonstrate to the satisfaction of a consular officer that they either will be covered or approved by health insurance within 30 days or that they possess independent financial resources to pay for their own healthcare needs. So having reviewed the basis of the President's order, the district court is now going to render its decision as to why this was or was not legal before the Court of Appeals can get to it. So let's first look to what the district court did. In finding that plaintiffs were likely to succeed on the merits, the district court relied solely on plaintiffs' ultra vires claim. So ultra vires just means beyond power or beyond the right to do stuff. So ultra just means above and vires is power. So above the power. Illegal is another way of putting it. Even though plaintiff's motion did not squarely raise the issue, the district court held that, at least in the context of domestic policymaking, the court thought was reflective of the proclamation, the Congress's delegation of the power to promulgate additional classes of inadmissible aliens under the relevant law was too standardless and thus falls under the non-delegation doctrine. So the district court said that this loose power was too vague and therefore was a improper delegation power to the executive. The court further held the proclamation violates separation of powers principles by effectively overriding and contravening the carefully crafted limitations that Congress has placed on the admission of aliens who are likely to become a public charge. Okay, so the first thing that the court has to consider is the standing issue, because in addition to a bunch of John Does, an organization also sued on behalf of its people. So the court has to consider whether or not the organization has the standing to bring this lawsuit for the violation of law. So let's discuss standing, always a good place to start. Organizations can assert Article 3 standing in their own right under the doctrine of associational standing. LawNet, which is the organization that is suing here, relied on Haven's realty theory rather than on association standing, however. In that case, the Supreme Court held that a fair housing organization that provided counseling and referral services for low and moderate income home seekers suffered a cognizable injury in fact for Article 3 purposes when the defendants allegedly racially discriminated steering practices, and steering is the technical name for what happens. If you go to someone like a real estate agent or a bank and you I want a loan or I'd like to look at houses, and steering is that they are directing you. They are steering you to certain neighborhoods on an invalid reason. Namely, race is the one that it most comes up on. So the idea is a black customer comes into the bank or a black customer comes into a real estate agent. It's like, I'm looking for a home. And they give a whole bunch of criteria. And there's a whole bunch of places that would theoretically satisfy the criteria the agent gives. And then what steering is that even though there are perfectly valid choices that are within the domain of what the customer asks for, they only take the customer to black neighborhoods or they steer them away from white neighborhoods. They never make it overt that you can't look at those places. It's just that they select that for that illegal purpose. So that's steering, in case you want to know what that is. Anyway, so they had these racially discriminating steering practices causing the organization to devote significant resources in assisting such home capers to identify and counteract defendants' practices, thereby frustrating the organization's efforts to assist equal access to housing through counseling and other referral services. We conclude the organization here, LawNet, showing below was sufficient to establish injury in fact under the relevant case. So the organization can sue, so standing is not a problem in this particular case. We review the district court's decision to grant or deny a preliminary injunction for abuse of discretion. The district court's interpretation of the underlying law, however, is subject to a de novo from the first start review. A plaintiff seeking preliminary injunction must establish that they're likely to succeed on the merits, that they're likely to suffer irreparable harm in the absence of it, and the balance of equities tips in their favor, and it's in the public interest. This four-part test should seem very familiar. This is the standard four-part test for all preliminary injunctions everywhere. It comes up all the time. Yeah. Are you likely to win? Were you hurt? How much damage will it cause one party? How much damage will it cause the other party? What's in the public interest? Yeah, that's the four-part test for injunctions. Likelihood of success on the merits is the most important factor. When the government is a party to a case, the balance of equities and public interest factor emerges. The Supreme Court has already rejected the broad theory that the president cannot use the relevant law to impose additional restrictions that address subject areas already expressly covered by more limited restrictions elsewhere within the law. Instead, the Supreme Court was willing only to assume the law does not allow the president to expressly override particular provisions of the law. Applying this standard, the court concluded that the plaintiffs in that case had failed to establish any contradiction with another provision of the relevant law. And because the proclamation otherwise satisfies the prerequisites of the law, the court has held the proclamation was squarely within the scope of the authority. Under these standards, the proclamation is likewise well within the President's authority under the relevant law. So perhaps surprising people who thought the Ninth Circuit would rule against Trump, actually no, as it turns out, not so much. The Ninth Circuit actually ruled for Trump. I know. Amazing, but it happened. So even though the district court issued the injunction, the Court of Appeals reversed and said that President Trump actually didn't do anything wrong in this proclamation. I know. I'm surprised. But President Trump gets a win. It might be a little bit late, but he does get it. He was right the entire time. This is a thing the president can do under the relevant law. So, hey, we can be surprised by the Ninth Circuit. That's a thing that happened. Plaintiffs nonetheless contend that the finding required by the law has not been made because, in their view, the president's supporting explanation for that finding in the proclamation is inadequate. The Supreme Court rejected a similar argument in the prior case of Trump versus Y, and rejected here as well. Indeed, the court has found it questionable. The requirement to make a finding is accompanied by any sort of requirement to actually explain the finding in any detail. Even so, Trump versus Y noted that the proclamation at issue in the case was more detailed than any proclamation previously issued under the relevant law, some of which contained mere bare-bones explanations as short as 1 or 5 sentences long. So one of the things that the people in this case said was you didn't explain yourself well enough, and the Supreme Court in a related case said, well, as it turns out, you don't have to actually explain yourself. You just have to make findings. You don't have to explain them. And previous ones that have been 1 sentence long have been upheld as valid under the law. And then in this particular case, they then reached this conclusion. Here, the proclamation concisely explains the adverse impact that uncompensated health care costs have on the American people, federal and state government budgets, private and public hospitals, and other stakeholders. It also points out that lawful immigrants are 3 times more likely than U.S. citizens to lack health insurance, further exacerbating the problem of uncompensated health care costs on the American health care system. Considered in the light of substantial deference owed to the president in this area, as the Supreme Court determined in Trump versus Y, these explanations are adequate to support the conclusion that restricting the immigration of persons who lack unsubsidized health insurance will avoid an impact that would be detrimental to the interests of the United States. Plaintiffs contend that the proclamation nevertheless exceeds the president's authority under the relevant law because, in their estimation, the proclamation conflicts with other provisions of law. In addressing similar arguments in Trump versus Y, the Supreme Court rejected this court's view that an entry-restricted promulgation under this law is invalid if it addresses matters of immigration already passed upon by Congress and thereby conflicts with the immigration law finally recited regulatory scheme. So the president can, in fact, make regulations beyond what the statute otherwise provides for, because the statute itself provides for that ability. So whatever else careful balance there might be, the statute allows the president explicitly to make other regulations, and he's done that. And then they say, well, that's not fair. You've upset the careful balance we made. But the careful balance included my ability to do stuff, and now I've done stuff. So you can't complain about a power you gave me. Maybe don't give the president this power if it really upsets you that much. But you did, and I used it. Court said, yep, you can do that. In lieu of the broad congressional displacement theory, the Supreme Court was willing only to assume the relevant law does not allow the president to expressly override particular provisions of the law. We likewise assume that such a limitation applies to this section, and we further assume it also precludes the president from expressly overriding provisions of statutes other than the immigration law, for example, the Affordable Care Act, because that would be another provision of law. So the president can't, through this mechanism, violate the law. He can't, do something that the law otherwise would forbid, but he can do something not done that. And then the court goes on to note the standard would be met under Trump versus Y, where there would be a conflict between the statute and the proclamation that would bar the restriction. So if what the president says doesn't conflict with any other statute, then it's within his power because the Congress gave the power for him to do it. The proclamation does not expressly override the feature of the Affordable Care Act as dictated by Trump versus Y because the two provisions operate in different spheres. The Affordable Care Act extends tax credits only to aliens who are already lawfully present in the United States. The proclamation, by contrast, applies only to aliens seeking to enter the United States. So the Affordable Care Act only applies to aliens who are already here. The immigration law dictates who can come here. The proclamation, therefore, doesn't conflict because the Affordable Care Act only applies to aliens who are here. If you're not here, it doesn't conflict with the Affordable Care Act. So there's no problem there. If you're not here, then the ACA doesn't apply to you. And the president doesn't want you to be here because you don't have health care or you can't get health care if you're here. So, yeah, I mean, he can do that. It's fine. Plaintiffs also contend, and the district court held, that they're likely to succeed on their argument the proclamation conflicts with the public charge provision of the law. We again disagree. The relevant law of the statute renders inadmissible any alien who is likely at any time to become a public charge. In deciding whether an alien is likely to become a public charge, a consular officer must consider, at a minimum, an alien's age, health, familial status, assets, resources, financial status, education, and skills. At the broadest level, there is undoubtedly some overlap between the immigration statute's exclusion of those likely to become a public charge and the proclamation's exclusion of those who will be financially a burden to the United States healthcare system. As a result, plaintiff's argument might have substantial force under the opinion of this court that was reversed in Trump versus Hawaii, where we held the president could not impose additional restrictions that address matters of immigration or passed upon by Congress. But the Supreme Court said not so much. So if we were interpreting our own case law, we would have said yes. However, the Supreme Court disagreed with us. And Supreme Court wins. So if we were interpreting our own version of Trump versus Hawaii, the one that we wrote, we'd say this is in the same category. The president can't do this. And the Supreme Court said, yes, he can. So, yes, he can. So the Supreme Court disagreed with us. It said that such an overlap was not enough by itself, and that at the very least, the plaintiffs had to show the proclamation was expressly overrode particular provisions of the law. So merely because it touches a similar domain that's contemplated in the law is not enough. Just because there's overlap is not enough. What the president does has to actually override a provision of the immigration law or perhaps some other law. But if he doesn't override it, the very fact that it deals with a similar subject matter is not enough. So if it were up to us, we would say the president can't do this. But Supreme Court already whacked us upside the head. And so, yeah, he can do this. The Ninth Circuit at least knows how to listen to the Supreme Court. They got that going for them. That's nice. The same is true here. The proclamation does not override the public charge provision or its multi-factor inquiry. Rather, the proclamation merely creates an additional separate ground for inadmissibility, which is within the president's authority under the relevant law. So, the president has just merely clarified and added to, not contradicted, so it's legal. Contrary to what the district court concluded, it makes no difference where the additional entry restrictions are imposed under the relevant law based on assertedly domestic policy considerations. The district court's demand for additional congressional guidance when domestic concerns are at issue lacks a principled basis and is unworkable, because all additional restrictions under the law on who may enter the United States are ultimately based on the detrimental impact of that person. So if the president was unable to consider domestic policy considerations as opposed to international ones, I suppose, but if he was unable to consider domestic policy considerations, then everything he did under this would necessarily be invalid, because all of them are based on whether the alien's presence would be detrimental in the United States, which is ultimately a domestic consideration. It's like who we're admitting into the United States does seem like a domestic consideration, yes. Apparently someone at some point disagreed, though, and the district court disagreed for some reason. Indeed, the grounds for it being admissible in the relevant law of the Immigration Act underscores how a decision of whether to admit an alien can have adverse consequences. For the foregoing reasons, the district court abused its discretion in granting the preliminary injunction enjoining the proclamation's implementation. Because the preliminary injunction should not have been issued in the first instance, we need not address where the injunction's universal scope was overbroad. The order of the district court is reversed and preliminary injunction is vacated. So that brings us to the end of the Ninth Circuit Court of a case in the case of John Doe, number 1, and all others versus Donald Trump. In this case, Donald Trump issued a proclamation that said that anyone who could not get health care and could not pay for their own health care couldn't immigrate legally into the United States. And a bunch of people sued and said Donald Trump can't do that. The district court said Donald Trump can't do that. And perhaps surprisingly, the Court of Appeals said, yeah, Donald Trump can do that. It's within the bounds. And people are like, wait, what? Yeah, well, that's what the law says. You gave the president that power. He has the power to make these determinations. And the Supreme Court's made it clear that as long as he's not contradicting what's already in the law, he can do what's there because you gave him that power. And like, that's not fair. We didn't want the president to use the power that way. It's like, well, That's the thing about power, man. When you give someone power, they can use it for good or use it for things that you don't like. So maybe consider that. But for the moment, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.